mistake it to be an acquittal. Please desist from that temptation. That is not how court works. Last time I talked about the processes we have to go through. Now I want to remind you that sometimes when a court grants bail to an accused person, it is not an acquittal. You political accused persons make some mistakes. Court does not work on the power of the numbers. That one works for you in the field. There is specific questions that court expects in a particular stage, and whether who you have to go through that process. Where is my client? Oh yes. Oh yeah. So I'm talking to you as well. I'm talking to you as well, and I will invite you later. So I'm imagining the economic loss so far this case has caused to the country. I'm seeing everybody, every voter, every supporter in solidarity with. You can just imagine. But the power of the numbers does not change the legal status. So in the future, the crowd is not called for in courts, because what matters is certain questions. Have you passed this question? Have you passed this? Have you passed this? If the answer is yes, then a celebration can be there. Then another thing is that we as judicial officers are not influenced by the power of numbers. Otherwise, the moment you are influenced by the power of numbers, you cease being a judicial officer. The constitution you people made for us says justice shall be done to all irrespective of social, economic, and political status. And this is what we are going through. Every day, including yesterday, including last week, for all the years a judicial officer stays in the office. Our business is sending people to prison and releasing those who are innocent. But the accused person today is a special one because he's attracting a big crowd. But that crowd only is very good. And I swear, if you are celebrating, that is very fine. But I wouldn't expect in the future, if we are having court hearing. Anyway, some members could be stakeholders who are interested to see, who are good at trying judicial officers, to see how court conducts in a particular situation. But the power of numbers, the power of what doesn't influence court. I want to inform you, the accused person and other court users, that even when you see the prosecutors prosecuting you, they don't have any personal. It is just a calling, like you chose to be a politician. It is a calling of a prosecutor to handle a job where most of you are feared to be, to prosecute. Because his duty is to ensure that if a crime has happened in society, it has to be prosecuted. So I want to advise you, and I also want to bring it to your attention. The duty of a prosecutor is to ensure that evidence is gathered, and once the evidence is there, it is properly read to court. Then the lawyer's duty is to ensure that he defends you, while the prosecutor's role is to make sure that you come closer to justice by reading evidence. The lawyer's role is to make sure that you are distanced from. And then the biggest trouble is on a judicial officer who has to decide when matter have been presented by two competing parties who have the same knowledge as a judicial officer. So I want to always encourage you. That you respect professions. You respect professions because that's whatever a person does in his professional capacity, unless it is mandated. Whatever a person does in a professional capacity, that is what he's supposed to be. Are we together? Yes. The court of public opinion can always wait. Please, this is a court of law. This is a court of law. If a person wants to answer cases in a public opinion, then he will come back in 2016 or 2026 or 2020, whatever. But here is a court of what? So whatever we do, and we do them professionally, please respect us. Yeah? Please respect our decisions, and we try our best to make sure that the best comes out of us, because the constitution we made for us is that justice, judicial powers is derived from the people, shall be exercised in the name of the people, in conformity with the norms and aspirations of the what? Of the people. We try our best. There is nobody, this prosecutor or the team of prosecutors handling the file may not even know where the accused person is living, may never have even had tea on the same dining, and practically you have different ages, and therefore you can never have competed for even a girlfriend or whoever. So by all standards, there is no reason whatsoever why a prosecutor can prosecute an accused person with a bad heart. But whatever a prosecutor does is very professional, and that's what he's supposed to do. There is no reason why a judicial officer can pass a wrong decision to send you to prison if it is not called for, because we judicial officers are isolated from you, the greater community. We are busy here trying to make sure that justice is not only done, but it seems to be done. We don't meet you, we don't interact with you. So there is no judicial officer who takes a decision out of emotions. And there is no judicial officer who can be influenced. A judicial officer can be influenced by anything. That one ceases to be a judicial officer. So when you are subjected to these processes of the law, please accept that we are doing our work, and also while you are doing your work, we are very busy clapping. You find us on your rallies trying to clap for you when we go back to our constituencies. But when we come to our constituency, please respect us and don't think that whatever decision is reached out of a personal whatever or any influence. No. We took oath to do justice to all, and we shall always ensure that justice is done. I know I'm expected to speak only 3 words according to the mindset of all of you are here. Number 1, somebody wants to hear the word release. That's the first one. And that's the greater majority, including but not limited, those who are outside and those who are online. The other word is Father. You see, you even know the words. Those are the 3 words you want me to speak. But I know you are coming here as visitors. You don't visit us when we have no issue, when you have no issues. So listen to me, and the words I'm going to speak to you, I put them in writing, and I spent some good time trying to make sure that whatever I present to you is what I perceive with my professional experience, knowledge, and heart and analysis. So please, I want to ask you, like I told you last time and commended you, to remain a peaceful community. When you become a peaceful community, the problem is not visited on you, much as some of you can end up having personal issues or committing other offenses. So I want to encourage you that in the future hearings, you can do your other work, save for these people who are already rich and they are spending leisure because there is a lot on account. Yeah? But for those who are still struggling in life, you don't need to come to court every day. Yeah? Because a certain accused person has come. I want to finally advise, because this is the only opportunity I can talk to you and you listen. After reading, some people will not listen to me. The accused person in the system of judicial system, there is an issue or a component called pre-bargaining. Pre-bargaining is when an accused person assesses the evidence best known by him or her and discovers that in the court of my conscience, if I was given an opportunity to sit in the judicial seat, I would convict myself. If you convict yourself, because it is only you who knows exactly what transpired, and it is only you who knows the detailed part of the procedures that happens in certain cases. If you would convict yourself, please don't be like this person who says it is better to die standing than living on my knees. Don't hesitate to consult your lawyer to approach the prosecution for negotiation and discussion. You know, when a person says, I am sorry, I did this, is different from, even if it is a child, is different from a person who says, me, I didn't. You ate sugar. Me, I didn't. It is different. And when we are sentencing, if I may tell you, the number of times the case takes, the resources, all these are resources. Yeah? All these are resources. The resources, it costs the country. The resources, it costs the community. Now, I'm told there are so many people from Uganda who not work today. They want to follow their leader. But if, for instance, you sit in this seat and find that you are guilty, you would convict yourself. It is always good to enter into a plea bargain. Because at the end of the day, the case will still end. Even if I died today, this case will do what? We have to be decided. Systems will always continue doing what? Will always continue working. And many people fear one component. I'm talking to many. Many people fear losing employment. You die with a problem. Now, you have a land, you have a home, and you will see, I'm about to be, you have a home, you have acquired whatever you have acquired. Who tells you that when you lose employment and say, I'm sorry, please let me enter into a plea bargain? People think you are getting ashamed. But somebody who says sorry, I don't believe is the same as a person who is proved that you refuse to say sorry, I committed this offense. So I know you have lawyers, but I felt I should talk this in this big audience, because there are those who have never committed an offense and therefore have no business with lawyers. And there are those who are coming to court for the first time. And I also want to have several eyewitnesses to this. For us as judiciary, when the prosecution brings evidence, we shall listen to it. If it does not sustain a charge, we shall acquit you. But if the evidence they bring, according to how your lawyers will advise you, and according to how you can advise yourself, is enough to convict you, who are we to acquit you when you yourself and you are on the advice of your lawyers can convict yourself? So I want you to study this. The purpose of bail is not about freedom. Many of you are looking at the freedom of the accused person. No. The purpose of bail is to allow the accused person to be out to prepare how to manage this case. And this case, he has to prepare to manage it legally, not otherwise. Yeah? You gather your evidence. If you have any defense, yeah? You organize yourself, but you remain under the jurisdiction of what? Of court. Whatever you behave, the way you behave outside, you remain under the custody of court, much as physically you are at a distance. Meaning that when you do certain things contrary to the orders court may put, just in case you are lucky to get bail from court, then court will recall the trust it gave you. So, be informed. Be informed that bail, when abused, court recalls it. And there is another procedure which has developed in the judiciary present. People used to think that when I run away, the case will die. No. When you run away, we proceed with hearing evidence in your absentia. We shall evaluate evidence in absentia without you giving anything in the defense. If the evidence is so strong to be convicted, we shall convict you and even sentence you, and the punishment will remain hovering until when you will ever be arrested in whichever country. So running away sometimes doesn't work, because our law gives us mechanisms of dealing with that. So I want to ask all of you who may not necessarily be accused in this court, but having issues in other courts, always respect court processes and always behave according to the culture and norms of the institution. This is judiciary. Don't behave as if you are on a public rally. Are we together, members? I've talked too much. I want to stop here and do judicial work. If what I've been doing is not judicial. Okay.
Uganda DPP versus Honorable Amos Lugorobi.
Chief State Attorney. I am together with Ms. Safina Kireke, Senior State Attorney. We appear jointly for the prosecution who are the respondents in this matter. Counsel Isari John, together with the Counsel Tony Tumukunde, appear for the applicant, who is the accused person. The accused person has been duly introduced before this honorable court. The matter is for ruling in a bail application. We are ready to proceed by receiving the ruling. It is ready.
For the applicant, we are ready. Even from court, the ruling is ready, and despite if we may make some small corrections as we proceed, in a few minutes, whoever wants a copy, it will be ready after court. So this is Honorable Amos Lugorobi. Which language do you understand? Because it is possible that the language would have changed.
Your Worship, I understand English.
You will need to speak a bit louder if the microphone is far. It's not on. Yes. Oh, then you speak louder. I'm told it is not on. You speak louder.
Your Worship, I speak English.
Okay. So, having confirmed that you still speak the language of court, I will proceed to read this ruling in English, which is the language of court. And this ruling is in respect or coming from High Court. No, it's coming from court case number 35 of 2023 in the Anti-Corruption Division, and is against Honorable Amos Lugorobi as the applicant, Uganda as the respondent, represented by the DPP, and I myself, I may not have introduced myself to you. My name is Albert Asimu. I'm the acting senior principal magistrate, grade 1 of this division. This is to I've introduced to you because it takes when sometimes you get wrong spellings of your name. And sometimes it is good. I'm Albert Asimu. Okay? So this is a ruling. On 17th April 2023, Honorable Amos Lugorobi, male adult Ugandan, a minister for state planning and economic development, and a member of parliament of Mtenjeru North constituency in Kayunga district, herein referred to as applicant, was charged with 2 counts of dealing with suspect property contrary to Section 21A of the Anti-Corruption Act of 2009 as amended. The particulars of the offense under count 1 were that on 14th of July 2022, between the 14th day of July 2022 and 28th February 2023, at the office of the Prime Minister's office, stores located at Namambe, Mukono District, and different places in Matuga, Wakiso District, and Tenjeru North constituency in Kayunga District. The applicant dealt with government property with 400 pre-painted iron sheets marked Office of the Prime Minister, having reason to believe that the said iron sheets were acquired as a result of loss of government property, which constituted the offense under Section 10 subsection 1 of the Anti-Corruption Act of 2009 as amended. Similarly, under count 2, the prosecution alleged that the applicant between 1st day of February 2023 and 16th March 2023 at the office of the Prime Minister's stores and in different places in Matuga, Wakiso District, and Tenjeru North constituency, Kayunga District, the applicant dealt with government property with 300 pre-painted iron sheets marked Office of the Prime Minister, having reason to believe that the said iron sheets were acquired as a result of loss of government property, which constituted the offense under Section 10 subsection 1 of the Anti-Corruption Act of 2009 as amended. During pre-taking, the applicant was represented by Counsel John Isabiye and Counsel Tony Tumukunde, while the prosecution was represented by a team of 4 state attorneys, 3 of whom were chief state attorneys, namely Baile Stanley Moses, Bisamunyu David, and Biwaganya Jonathan, who appeared jointly with Safina Bireke, a senior state attorney. When the charges were read, the accused person, now the applicant, pleaded not guilty to all the charges, and court accordingly entered a plea of not guilty on each of the 2 counts, whereupon counsel for the applicant proceeded to make an oral application for bail. Article 23, Clause 6, Paragraph A of the Constitution of the Republic of Uganda provides that where a person is arrested in respect of criminal offense, that person is entitled to apply to be released on bail, and the court may grant that person bail on such conditions as court considers reasonable. However, the grant of bail is at the discretion of court upon being convinced that the accused person will return to court as and when he is required. In determining whether the accused person will abscond or return to court when granted bail, court shall have regard to the provisions of Section 77, subsection 2 of the Magistrate Courts Act, as stated hereunder. The following are what court considers when considering to grant or not to grant bail. 1, the nature of accusation, the gravity of the offense charged, and the severity of the sentence which conviction might entail, the antecedents of the applicant so far as they are known, whether the applicant has a fixed place of abode within the jurisdiction of court, whether the applicant is likely to interfere with any of the witnesses for the prosecution or any of the evidence to be tendered in support to the charge. The other considerations court must make before deciding whether or not to grant bail to the applicant include 1. Whether the accused person has on previous occasion, when released on bail, failed to comply with the conditions of his or her bail. Next, whether there are other charges pending against the accused person. Next, whether the accused has sound sureties within the jurisdiction of courts who will undertake that the accused person shall comply with bail conditions, and the age as well as status of the accused person. Counsel for the applicant presented a total of 7 sureties, together with certified copies of their bank statements, 5 land titles, including one of the accused person, and the statement of such from Ministry of Lands, and the letter of introduction from the sureties representing places of residence, and several detailed medical reports, and prayed that the applicant be released on bail. In reply, the state opposed the application, arguing that it needed only like 2 weeks to conclude the investigation, and that the applicant, being a high-profile accused person, would interfere with the investigation and therefore needed to be kept in custody. The prosecution further argued that there was need for time to verify the documents as they were bulky, in addition to expressing the worry that Honorable Kakoza, a member of Parliament in the East African Legislative Assembly, could not pass the test as a substantial surety. Rejoinder was made, and the court agreed with the prosecution that indeed there was need for time to verify and properly analyze the bulk of documents that had been tendered in support of the application. Specific analysis of the consideration for bail as stated in the law. Number 1, nature of accusation, together with the gravity of the offense charged and severity of the punishment which conviction might entail. The issue to do with the nature of accusation is clearly stated in the introductory part of this my ruling, but I wish to add that dealing with suspect property under section 21A that creates the offense of loss of public property under section 10 subsection 1 of the Anti-Corruption Act, upon conviction, the accused person, now the applicant in this case, will be liable to imprisonment for the term not exceeding 10 years, or a fine not exceeding 240 currency points, or both on each count, and the sentence in terms of imprisonment can either be concurrent or consecutive, depending on the decision of court based on the evidence adduced by the prosecution and both parties, both parties. For avoidance of any doubts, a currency point according to the schedule to the Anti-Corruption Act is equivalent to 20,000 shillings, meaning that in terms of fine, the maximum is 240 multiplied by 20,000, which translates to 4.8 million on each count. So you can be convicted to custodial, which is 10 years on each count. If you are to go for a maximum, that would be 20 years. Or to a fine, which is 4.8 on each count, meaning that you multiply by 2 counts if you are convicted, or both. I want to emphasize the component of both. Both comes in depending on your conduct during the trial process. It should be noted that, as submitted by counsel for the applicant, this court has jurisdiction to entertain the matter and their bail application under the law that creates this division of High Court and Magistrates Court Act, which is the law that relates to the establishment, constitution, and jurisdiction and practices and procedures before magistrate courts. What are the antecedents of the applicant so far as they are known? Court must consider the antecedents of the applicant because it would indeed be a mockery of judicial process and a miscarriage of justice if bail is granted to a person who has a staggering record of previous convictions to his name. There were no submissions made on the antecedents of the accused by both counsel for the applicant and the prosecution. Counsel for the applicant only told court that his client had been arrested on Friday evening before being arraigned in court on Monday. According to the documents on record, the antecedents of the applicants are only talked about by the chairperson LC1 of Chizungu village. Is he around? Yeah. In the words of the chairperson, he is quoted to have recommended as follows. Recommendation for Honorable Amos Gorovi. I wish to inform you that the above mentioned person who is accused in this court is a permanent resident of my area. He is a law-abiding citizen and resident without any known criminal record. I therefore recommend that he be granted bail basing on my own recommendation. Yours sincerely, Katwere Kabogoza, chairperson LC1 on 0752 621125. The prosecution, while objecting to bail application, did not bring any of the negative antecedents of the applicant to the attention of court. In absence of the evidence or information that suggests that the applicant has a bad antecedent, makes me believe that the recommendation of the chairperson LC1, the recommendation of chairperson LC1 that the applicant has a good antecedent. Next consideration, whether the applicant has a fixed place of abode within the jurisdiction of court. The issue as to whether the applicant has a fixed place of abode was never contested by the prosecution. Without prejudice to the foregoing, counsel for the accused person had tendered in a certificate of land title referred to as Block 261, Plot 730, Mengo District, Chadondo County in Sabagabo Sub-County. The said private mile land measuring 0.161 hectares is indicated as having been transferred to the applicant on 29th June 2016 under instrument number KCCA 0002942. According to the statement of such, dated 12th April, according to the statement of such, dated 12th April 2023, Registrar of Titles by names of Madina Nabukeda indicated that land at Lukuli, Chadondo, Block 261, Plot 730, measuring 0.1610 hectares, belongs to Gorobi Amos, of PO Box 7178, Kampala, and was registered on 29th June 2016 at 27 minutes past 2 under instrument number KCCA 0002942, and that this land title did not have any encumbrance. This information corresponds with the statement of such dated the next day, the 13th day of April 2023, issued by another registrar of titles by the name called Mark Dahagire. The ownership of the home and property described in the certificate of title was confirmed by the letter addressed to this court by the area LC1 chairperson of Chizungu Village Urban Council, located in Makindi Division, Makindi Ward, Rukulinangada Road, in the letter dated 10th April 2023, in which the chairperson recommended that the applicant was a permanent resident of the village, and considering the above evidence, I am convinced that the applicant has a fixed place of abode. Whether the applicant is likely to interfere with any of the witnesses for the prosecution, or any of the evidence to be tendered in support of the charge. The issue to do with interference with any of the witnesses for the prosecution was the main contention of the prosecution on the ground that the accused being a minister would be able to influence investigation. The prosecution, while objecting to bail application, informed the court that the remaining investigation would be completed within a week or two. The prosecutor went on to quote the provision of section 77(2)(e) of the Magistrate Courts Act, Cap 16, which is one of the considerations, as earlier stated above, when considering, when handling a bail application in a magistrate court. This issue of fixed price of a bond was exhaustively discussed in the case of Chiza Besigye, referenced as criminal application number 83 of 2016, arising from case number 16 of 2016 and another case number 14 of 2016, where Colonel Chiza Besigye was the applicant and Uganda was the respondent in the matter before Mr. Masaru Musene, before Honorable Justice Mr. Masaru Musene. He has since passed on. May his soul rest in peace. In the matter of application pending trial, where it was said that the court should not always believe in suspicion. For example, in the said application, the judge quoted the words of another judge in the case of Panju versus Republic, cited in 1973, East Africa, at page 282, that if courts have simply act on allegations, fears, or suspicions, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. I wish to state that I believe in the reasoning and therefore wish to adopt it. I entirely agree with the holding in the above case in the sense that although the applicant is a minister who is believed and known to be an influential person, as everybody can see, with large political following, being a member of parliament on the Tejero North constituency in Kayunga district, that should not deny him liberty, especially on allegations which have not been proved or brought the attention of courts. Further reasoning can be borrowed from the reasoning of Honorable Justice Ogora, the then principal judge in criminal miscellaneous application number 228 of 2005 and criminal miscellaneous application number 229 of 2005, when Colonel Dr. Chiza Besigye was in court at that time. Honorable Justice Ogora, the principal judge as he then was, emphasized that the right to liberty is crucial in a free and democratic society. Like Justice Masaru Musene, I am persuaded to quote the famous passage from the ruling of Justice Ogora as it is pertinent and applicable in the present case and the circumstances. Honorable Justice Ogora had this to say. Liberty is the very essence of freedom and democracy. In our constitution, in our constitutional matrix here in Uganda, liberty roams large. The liberty of one is the liberty of all. The liberty of one must never be curtailed lightly, wantonly, or even worse, arbitrarily. Article 23, clause 6 of the Constitution grants a person who is deprived of his or her liberty, like the accused person now, the applicant, the right to apply to a competent court of law for the grant of bail. The court from which such a person seeks refuge or solace should be extremely wary of sending such a person away empty-handed, except, of course, for good cause. Ours are courts of justice. Ours is the duty and privilege to jealously and courageously guard and defend the right of all in spite of all. That's the quotation from the Honorable Principal Judge then. In the case of Uganda IGG versus Kinene Muhammad and Chiwahibwe Annette, criminal appeal number 17 of 2019 at page 8, the head of this division, Justice Lawrence Dudu, while summarizing the duty of the prosecution and the basic principles of criminal law in criminal matters, guided that suspicion, however strong, does not prove an allegation. Considering the fact that the prosecution suspects that the accused will interfere with investigations, compared to the right to liberty, in light of authorities stated above, I'm persuaded to believe that the accused, when released, may not interfere with investigations. The applicant and all court users should be informed that resolution of a legal question is not based on and influenced by the power of numbers. We as court follow clearly known procedure, and each case has specific questions to be answered. It is a mistake to use political approach in legal matters. To completely cure the prosecution's contention, just in case the applicant in totality meets all considerations and is to be released on bail, the applicant is advised to desist from temptations of interfering with prosecution investigations or witnesses, as long as the case against him is still pending in court, and actually, even after the conclusion of the case, as this will lead to automatic cancellation of his bail when it is being tried and being charged of other offenses arising from interference with prosecution investigation or witnesses, respectively. In regard to other considerations, court must make before deciding to grant or not to grant bail include: 1, whether the accused has on previous occasion when released on bail failed to comply with the conditions of his or her bail terms. This information was not available to court, and therefore court has no reason to believe that the applicant will fail to comply with the conditions of bail if released. In criminal miscellaneous application number 18 of 2022, arising from Uganda Road Criminal Court case number 1559 of 2022, Justice Mike Erubu guided that bail terms should be safeguarded, that once a accused person is released on bail, he will return to court for his trial. The judge, with reference to the decision in the case of Charles Onyango Ogo and another versus Uganda, decided in 1997, stated in his ruling that court should not impose such tough conditions that the whole bail looks like a punishment. Bail is not a punishment, but merely intended to secure attendance of the accused person for trial. Bail terms or conditions must not be too high to be out of reach or appear punitive. They should not be too low to be outrageous or ridiculous. They must fit the circumstance of the individual case. The primary consideration is that whether they will oblige the accused person to be in court for a trial, whether there are other charges pending against the accused person. No evidence was laid to show that the accused person has other cases pending beforehand. Without the prosecution coming up with such evidence, it can be presumed that there are no other charges pending against the accused person until the contrary is proved. Whether the accused person has sound sureties within the jurisdiction to undertake that the accused shall comply with the conditions of bail. The applicant in this case presented a total of 7 sureties, and each presented certified copies of their bank statements as proof that they are in gainful employment, or four of whom presented land titles as proof of residence. A critical study of particulars of the sureties reveals that 3 are members of parliaments, 2 in Ugandan Parliament, and 1 in East African Legislative Assembly. The prosecution objected to 2 the prosecution objected to 2 out of 6 and alleged that Honorable James Kapoza, who identified himself as a member of parliament in East African Legislative Assembly, was outside the jurisdiction of this court, as he was presumed to be domiciled in Arusha, to be resident in Arusha, and therefore not able to remind the accused person to attend court as and when required. Counsel for the applicant argued that he is within the jurisdiction of this court as he is a resident of Kizungu Urban Council in Makinde Division. According to the introductory letter addressed to court, Honorable James Kapoza was introduced to this court by Mr. Katwere Kabogoza, the chairperson of LC1 of Kizungu Village. This is the same chairperson of LC1 who recommended the applicant as a resident in the area. This means that he is a neighbor or more close to the applicant than some of the sureties the prosecution found substantial. Considering this fact, I find Honorable Kapoza too as a competent surety. The prosecution had objected to Mr. Kalisa Karangwa Moses, the director of UNIC company and chairperson NRM Kayunga district, and a close friend to the applicant for over 10 years, on ground that his document had not been furnished to the prosecution. However, according to the document standard in court, Kalisa was introduced as a resident of Nakalilo, said the Njeru Ward, Kayunga Town Council. It should be remembered that the applicant is a representative of Njeru constituency, meaning that he is a representative of the surety in parliament. Court is aware that NRM is a ruling party in this country, and the fact that the applicant is serving the government as a minister makes me believe that the district chairperson of NRM is competent surety to compel him to attend court on political grounds. And as a district mate or a person who comes from the same district, it is my finding that he too is found substantial. Does age and health status of the chosen person matter in this application? Counsel for the applicant struggled heavily to appeal to court that accused was sick, and in the recent past he had undergone operations of their heart. Several detailed medical reports were tendered in evidence. The prosecution was of the view that Uganda prisons has the best facilities, which is indeed true, where the applicant will be treated as well. After adjourning for a ruling and upon scrutiny of all documents, court was convinced that truly the applicant was a sickly man who, in addition to medical care, deserved psychosocial support of his immediate family and friends if he met other conditions I've been discussing above. Having regard to the above circumstances and factors, having judiciously and meticulously weighed one factor against the other, I'm inclined to grant the applicant bail on the following terms. 1. The applicant will pay a cash bail of Uganda shillings 10 million. Yes. 2. He shall surrender his original land title, Block 26-1, Road 730, Mengo District, Chadondo County, in Sabagabo Sub-County. The applicant shall not leave this country without knowledge and permission of this court, and shall surrender his original diplomatic passport to this court. Each of the 6 sureties is also bonded in the sum of 100 million, not cash. The applicant is cautioned to desist from temptations of interfering with prosecution witnesses when the case is being heard and it is finalized. Failure to do so will lead to automatic cancellation of bail. This ruling is delivered in open court this 20th day of April 2023 in presence of all parties And just in case the prosecution is offended by my ruling, you have a right to appeal against it. That's the best that will come out of me. I want to thank you for your attention. I want to thank you for the patience. And I want to ask you to maintain the heart calmness. I want to wish you safe journeys back home. And I want to ask you to desist from temptations and trials of committing offenses. And where possible, if you can, distance yourself from allegations. Thank you. Much obliged. We are going to mention this matter. How much time will you complete the investigation? We don't need this crowd here every time and again. We want you to come when the event is fine.
Your Worship, much obliged. The prosecution prays for a short adjournment. The date for mention, by which time we believe investigations will have been completed. Within 2 weeks. We would have asked for 1 week, but the next week is very busy for us. We are proposing the 4th day of May, if it's available to do so, and defense counsel. Your Worship, 9th of May, if it's available, or 10th. 10th. The defense are saying 9th is not available.
Okay. There's a coincidence that I'm going for leave on 2nd May, and my leave ends on 29th. So I'm going to give you the earliest date in the month of June, and that is first June.
First June I have a high matter, but 2nd will be okay, Your Worship.
Is okay? Is 2nd okay to state?
There's no problem.
State. Is 2nd okay?
It's okay, Your Worship.
I am not retaining titles of the sureties. Please, after court, you can look at my stuff and decide for them. That would be harsh. It was being harsh, being talked about in the case of Charles Onyango, because land is a factor of production, and we know that you may need to transact with it. But as long as we know that we have given you a soft loan of 100 million, if you disappear, we shall find you on a rally in your constituency, and then you will pay it. Yeah? So those sureties who are tendering, we are telling your title, that will be enough, and upon payment 10 million. Then the sureties, please, you have taken a soft loan of 100 million. If you have been taking it for political mobilization, please know that if Amos gets the expectations of running away, you have taken that loan, and we shall find you wherever you will be. Okay? Please. So this matter is adjourned to the 2nd day of June at 12 noon, and we expect you, Honorable Gorobi, to abide by the directives. Okay? Please, if you want to get peace with court, always abide by it. You have capacity to address your supporters, to always be there. Who is preparing to receive you? They will remain there. They don't need to come here. Yeah? They don't need to come here. Yeah? You come with some few accompaniments and attend the trial. That tension of everybody attending here. You have seen me given questions which are provided below. I've answered one by one. Yeah? Even if I wanted, if they asked about place of abode and you don't have it, would I create it? So courts of law for us we follow certain what? There are specific questions, and even when it comes to deciding this case, there are specific questions that we expect evidence of the prosecution to answer. So this business of showing support to the country and the world, people know you by virtue of the time, by the time you become a minister, by the time you become a member of parliament, people know that you're a person who is very influential. Okay? So you can caution your people to remain at work, and you will give them feedback every time you appear in court to do so. I wish you Johnny Mercies as you travel back.
Sureties, please don't go. Sureties, don't go away. Tell sureties not to go. Nenda zikaipingile yulete bajje yo. Kowe kajje yo. Lete bagenda. Sureties, you have some documents to sign. Don't go.